Welcome to the Anson Solicitors podcast. I'm Martin Derrida. I am joined today by my colleague and fellow director. It's Neil Faunch.
Thank you, Martin.
A graduate, I think we've had a couple of these now, of what I like to call the Martin Derrida Legal Academy. So what I mean by that is, you were my trainee many years ago. Like, what year was that?
2007.
Yeah, 2007. And was your first 6-month seat with me, or was that not quite straight away with me?
I don't think it was quite straight away, but I think it was during the first year. So just as about we had the financial crisis. Yeah, I mean, because we were on the way in, we were discussing sort of different things that had happened over the years, and you reminded me, and we won't name the venue, of the time I had to take on the bouncers. We had to go down and take on the not so much the bouncers as the bailiffs who were cutting down one of the nightclub's electricity. But we went down, we sorted it out. And they managed to open on that evening,
They
Martin.
did,
Yeah.
which is yes, with electricity. I mean, a nightclub
Which obviously
without.
you'd need, wouldn't you?
Well, I guess they could have done it sort of a cappella or whatever, but, you know, lots of that stuff, it is true as the legal profession's changed and technology has changed. You sort of probably get out and about less to the client's premises too. Sort of, we're in an industrial part of Wolverhampton, post-industrial part of Wolverhampton. You were saying it sort of was a throwback a little bit to walking around these places sort of 15 to 20 years ago when you had to go and see the clients.
Well, I think so, and I think it's still a good idea to go and see people. You actually see them in their own environment. You can pick up things that you wouldn't necessarily from a telephone call or from a Zoom call or Teams call. So certainly what I do, I still very much like to go and see people in their own environment. In
the flesh, so to speak.
Yeah.
And of course, if you're selling property and there's plans and there's maps and there's drawings and there's everything else, physically seeing it really helps you, doesn't it?
Well, you can pick so much up that you wouldn't ordinarily if you were just showing the plan. You can see if the boundary's in the wrong place or there's something that isn't quite right when you try and compare the plan to what's happened on the ground. So in many ways it is still very beneficial to go and actually see the place for yourself.
It's something that you always try and do if you can, dependent on the transaction.
Mm.
You're a commercial property lawyer. You will regularly be submitting something that is in the news at the moment, which is the stamp duty form, which is what is it called, like STF or something? What's the name of it? The form?
Stamp duty land tax.
Yeah.
Is slightly different to stamp duty.
Okay, go on.
Stamp duty deals with the transmission of shares, or the duty that you pay on the transmission of shares. What particularly has been in the news is what you would pay on a land transaction, which is stamp duty land tax, or SDLT.
And are we responsible as that for lawyers to getting that paid, are we?
Well, submission of the form obviously falls to the lawyer to do as part of the transaction that you've been instructed on. But what's been in the news recently is about what figures are inputted into that form and what is ultimately the duty payable.
And this is paid by the purchaser. And so if you're acting for the purchaser, you fill in the form and submit it to them. Is that correct?
Yes. So the purchaser will be responsible for the payment of stamp duty land tax to HMRC.
Now, in terms of the specifics of this and how the sort of law changed is partially to sort of discourage or make more tax, I guess. The government introduced a policy that if you're a owner of more than one home, if you're buying a second home, you have to pay more stamp duty land tax.
I mean, over the years, they've tweaked and they've amended stamp duty land tax as government policies changed, really. And
is that something that's changed reasonably regularly?
Originally, you'd have one rate of stamp duty that was payable whether or not you bought residential or non-residential property. That's then changed to different rates and different slicing arrangements whereby you'd pay a certain percentage on the first amount of the property's value and then other values. And then they introduced an additional rate of stamp duty for those people buying second or residential properties, mainly to cover the people who are buying the holiday homes and the second and third properties who government policy deemed to pay more stamp duty.
And in terms of the rate, what if I'm going to buy my first time buyer's house today, I don't know, Is it different depending on how much it costs? Do you know the rates off the top of your head?
Well, you obviously first-time buyers may be eligible for relief, so it just demonstrates how complicated stamp duty land tax has become.
Yeah, and so I mean, of course, what we're talking about is Angela Rayner, the former Deputy Prime Minister. Now, in her circumstances, let's just ignore whatever the grace and favour property that she gets connected to her job. She was going to buy another house or a second home.
Or she did buy another home
in Hove in the where's your Hove? Which county is that in? The home county somewhere, Sussex. So she was going to buy a second home in Sussex, and at least to most of us, some people would have pointed there and say, well, actually, she's already got a house up in a constituency in Ashton-under-Lyne. Therefore, this is a second house, and she'll have to pay the higher rate of stamp duty land tax.
Yes.
However, there was on one level a complexity here because which surrounds the law of trusts and everything else, in that when she arguably did not own her family home, the property in Ashton-under-Lyne, because that was held in a trust.
So under trust law, she was merely a trustee of the property in Ashton-under-Lyne.
It's in her name, but it's not
in her
house,
name.
really.
But actually, she's not entitled to any of the proceeds of sale or any of the beneficial interest, we would say. And so she would be right to say that she did not own that property.
I've got a certain sympathy for this, right? Because I've only got one house. The law has been kind to me, but certainly not kind enough that the second homes and holiday homes, maybe in the future, if more people like and subscribe to this channel, that'll help. But I'm trustee as the sort of senior partner. This is not me trying to say this to make myself sound like Ron Burgundy and I'm a kind of a big deal, but because I'm the most senior lawyer in Anson's, I'm a lot of the trusts. One of the things that we do, like a lot of firms, is I'm usually one of the trustees. So I don't know how many houses or properties or pieces of agricultural land I'm the legal owner because I'm one of the trustees of the trust. But I would like to think that I'd still qualify if I moved house, sold my house and bought another one. I'd want to be paying the standard
rate as a replacement of your main dwelling.
Yeah, because I shouldn't be penalised for that. So what was the difference? So Angela Rayner, and we don't know all of the facts here, but she was a trustee, but not quite in the same way that I was.
No, the facts that have been publicised are that the nature of the trust of which she was a trustee was to benefit her son, who
had an accident or was
as part of an arrangement that had been put in place under the auspices of the court. And that existence of that trust for that purpose had meant that she was deemed to own that property still in Ashton-under-Lyne.
And this comes down to what the government always does, is it introduces some legislation and then it almost puts into play some kind of anti-avoidance measure.
That's exactly what this is.
Because what would happen is, if the law said you don't pay the second rate or the higher rate if you are a trustee, well, us lawyers, dare I say it, and the accountants will be creating all sorts of trusts to try and, pay less stamp duty for people. So it's almost there to say no. It shouldn't penalise, say, somebody like myself. It's not the Martin Derrida stamp duty exemption, but it's people like myself who might be nominal trustees of a number of trusts. But if your interest is more than being kind of a mere trustee, your interest is in that property. Presumably here, we think maybe that she lived in it and the property was for the benefit of her son. That pulled it into the category of being one of the trusts that fell outside of the exemption, really.
Yes, she was living at the property. There was an arrangement whereby she would live there. It was in her constituency. And from what we know, that trust was put in place for the benefit of her child who was under the age of 18. And as a consequence of that, she was deemed to still own it, even though she had no right to any of the proceeds of sale or beneficial interest in it.
Yeah, so on the surface, you might be forgiven for thinking actually that she does fall into that sort of exemption. But unfortunately, because of her living there, she didn't.
Yeah, I mean, it's very unclear about the nature of that trust, and I think that has also come out in the ethics advisor's report.
Yeah,
that it was complex. He acknowledges that, but nevertheless, what we now know is that trust meant that she was deemed still to own it, and so should have paid the high rate of stamp duty on the purchase of the new property.
As a lawyer, right, I can't, not always, but when some of this came out and she criticised the legal advice, and commentators were, and perhaps supporters of Angela Rayner were criticising the lawyers. I got quite defensive about the lawyers here. I was like, well, it's first of all, it's her responsibility to pay the tax, not the lawyer's responsibility to pay the tax. And on one level, a sort of specialist not even a specialist, a conveyancer, a small conveyancing law firm dealing with these complicated issues. It's not their responsibility. Saying it's their fault, it struck me as being harsh. Albeit the more I've sort of looked into it, I've got a little bit more sympathy for Angela Rayner here. Where do you stand on that?
This highlights that stamp duty land tax can be incredibly complicated.
Yeah.
Anybody who buys a house, I think, would accept, if you asked anybody, that they know of the existence of stamp duty land tax, and it's a tax that they would have to pay on the purchase of the property, and there are particular rates that you'd have to pay. However, when instructing a solicitor, I mean, the normal person would expect the solicitor to guide them on the amount of stamp duty land tax they would have to pay.
We fill in the form for most people, right?
And in most cases, it's very straightforward. If you're buying a house and you're selling your existing house, then it is very straightforward. But there are traps. And what this case has highlighted is how easily I think you can fall into a trap.
But I guess where it comes down to into sort of the blame game part of this, there is part of me that thinks that a lawyer who says, I think on balance that you don't need to pay this and you fall within the exemptions or whatever, even if they then, which appears to have occurred here, they've referred it to one of their trustee or the private client lawyers who specialise in trusts within the firm, and they have said the same. I actually don't think, I think that you're being slightly mealy-mouthed as a lawyer if you do say, we think it's this, but you should go and get independent tax advice. I think that you have to be a bit more forceful with saying, I mean, I've not read the correspondence, but I think that lawyers as a profession, we need to be a bit more forceful and more or less tell the clients that, look, if we're not certain, we need to get the expert in.
I mean, the correspondence isn't in the public domain as far as I know, but this troubles me because what seems to be the position is that two sets of lawyers,
I think within the same firm, maybe, but maybe not. I don't know.
I'm not
sure.
Even
sure that's clear.
Have reached a conclusion that the standard duty was payable, but then caveated that by suggesting that they need to go and get independent tax advice. Now, would the ordinary person who has been told by two people that the standard rates apply go and get independent tax advice?
I mean, it depends, right? With the relationship with your, I've been involved in purchasing my own first house, and you get the surveyor out, and there was a bit of a damp issue at the back, and my conveyancer at the time, Julie Tomasic, currently of this parish, said no, there's some damp specialists in Shenstone, go and get them to come and have a look at it, and they'll tell you, and you can try and negotiate. And I, of course, followed that advice, and I think that sometimes you have to be quite.
But did your original surveyor actually say, but actually we don't think this is a problem?
He hinted that it wasn't that big a deal, But my solicitor said he's saying it's not that big a deal, but why would you risk it? Why didn't you get it looked into properly? And I followed that advice. I think that sometimes lawyers need to be more muscular in their advice and more directional. Again, I don't know what they said, so I'm not.
I mean, if the advice was we don't know here because of the complex trust arrangements, that I think puts a different colour on it, doesn't it? Than if they said, well, we've looked at this, we're aware of the existence of the trust, you've disclosed this information to us, and actually we think the standard rate applies. Now, there may be some technicality about that by the nature of the trust that we simply don't know. The information isn't in the public domain, and that wasn't clear about whether or not those exemptions applied until actually the main tax advice was sought after it had all been publicised.
And ironically, the specialist tax advice is not from a lawyer typically. The people who we lean on, I remember me and you being involved in a case, I think it was concerning whether somebody qualified as a first-time buyer. Yeah. The tax advice came from an accountant or other different people out there. I know that he's been on the show. Jonathan Dudley's got a team that do some specialist at Crow. We've got some specialist stamp duty taxation people. There is also is it a law firm that does a little bit of this as well?
I mean, there are specialist stamp duty land tax advisors. Yeah. Some of them are annexed to the big accountancy firms. Others are bespoke to organisations.
They don't. I mean, in the couple that I've been involved in, they don't seem to be that expensive either. I'm sure, depending on the complexity, they can be, but like hundreds of pounds, not thousands of pounds. Whenever I've been involved in that,
but certainly in the conveyancing process, it is not ordinary to go and instruct another firm to give you stamp duty land tax advice. Perhaps it should be after this.
Okay. That if there's a complexity to it, that's what you do.
But I mean, who determines whether there's a complexity?
I think the lawyer who's taking responsibility for the file. If this was a probate matter, I was discussing this issue this morning on the question of capacity. If I go and see an elderly client, if they're completely compos mentis, I'll just crack on with the will. There becomes a degree at which I think there's a question as to whether capacity is there or not. Normally, at that stage, you would say, right, we're going to bring in a specialist assessor of mental capacity. Yana Aydin is one I know, by the way, very good. And bring them in to give some advice on, whether that person's got a mental capacity. And what I'm saying is the skill of being a solicitor, a conveyancer, is to sort of recognise what you kind of don't know and to say, well, this has crossed that threshold.
Well, it's to be the gatekeeper, isn't it? And what troubles me about this case is how in slow motion the car has come to crash, really, because you've got two sets of solicitors involved here.
Yeah.
And we still haven't taken independent tax advice. The lower rate of duty has been paid, and that's turned out to be wrong.
Yeah, as it's gone on, I sort of, the more I feel sorry, perhaps as a lawyer I would do, but for like everyone involved in it, I don't think this has been some sort of flagrant, dodgy.
No, and that's acknowledged, isn't it? Throughout, it's acknowledged in the ethics advisor's report as well that this is a circumstance she's found herself in, and but ultimately, obviously, the repercussions have been extremely severe, and there will be tax penalties and the extra tax due. And
she's lost her job over it, right? Yeah. And I think that all of this is a shame for her and politics, and people will either not like her or whatever. And I guess if you are a government minister, probably this sort of thing is beyond important to get right, to pay your right tax, particularly if you criticised other people for not having paid the right tax. I guess what goes around comes around. But I think that it's, I think it has been interesting, and I have observed how my own feelings, for want of a better word, on it, and my own feelings of culpability have sort of moved back and forth the more I learn of it, really. And I guess I guess one of the rules that we can all sort of take out of this is, to know what you don't know, and when it is something that you're not a specialist on, to first of all to obtain that specialist advice, but to quite muscularly encourage.
And it isn't something as a last minute thought at the end of the transaction. It's something to discuss at the beginning, and think about what is the stamp duty land tax I am expected to pay in this transaction.
Has it caused us to think about our own procedures a little bit and what we're asking clients at the outset? A little bit.
The question, you only get the answers back to the questions you ask,
of course,
don't you? Now, if you'd have asked here, do you own any other property? She would have been right to have to answered, no, I don't own any other property. So actually, it's a bigger question, because you can find yourself liable if you do not own any other property. That's what this has proved.
Yeah, and perhaps more people are going to be aware. And we asked, the question can't just be that simple one. It needs to expand on it. It needs to say, please list any trusts that you were a trust of.
Are you a trustee of another property, or do you have any trusts in place for your children under the age of 18? The inquiry, I think, needs to be more in depth.
Yeah, I wouldn't know. I would be able to find out. Of course, there is a list of the trusts.
Well, the circumstances here, though, are about specific narrow trusts for children.
No.
So people should know that. Not my
example. Yeah.
There are different arrangements for bear trusts and other types of trusts that you might be involved in.
I was making this all about me, Neil, which is quite a sort of. I'd be interested in.
But if you're buying your holiday home, I would suggest you do pay the higher rates.
Yeah, I wouldn't want a holiday home, because I wouldn't want to go back to the same place on holiday. One of the viewers of this podcast the other week made a comment on the socials about the fact that he couldn't believe that I, as a solicitor, admitted to going on holiday to Benidorm. So have you ever been to Benidorm?
No.
It's nothing to be ashamed of. It's a great place. The beaches there are fantastic. There is, down the one end, the old town of Benidorm is quite Spanish and picturesque. And yes, there is a bit of sort of fried breakfasts and Carling drinking going on down the other end. But I'd say it's, all life is there. It's quite a fun spot.
So you go back annually, do you?
No, but I did go there last year, and I might go there next year. But I say that, actually. I did. I went on holiday near Benidorm on a family holiday this year. It was sort of about a few miles outside of Benidorm, and it was good. It was warm. I recommend it.
Spanish villa it is then, Martin.
Maybe it needs to be a Spanish. But I wouldn't want to do that, because I wouldn't want to keep going back to the same spot. You want to go somewhere different, don't you, when you go on holiday? At least a different hotel, even if it's in the same. Even if it's the same town. I definitely don't want a holiday home in Hove. Have they actually got a beach in Hove, or is it one of those like pebble beaches?
I've never been.
I don't know either. I don't know what I'm even speculating on that and what the relevance of that is. Now, I wanted to come on to more what you do for a living, because interestingly, you're based in our Lichfield office. Quite a lot of the work that you do, it is property law, right? But it is focused on the agricultural community.
Yes, it is. So, and that takes a sort of a broad umbrella, really, from diversification projects to compulsory purchase issues. Particularly, we have a lot of clients that have been affected by HS2.
Yeah, loads of our farming clients, because it's gone right the way through our patch, hasn't it?
And for those that have diversified and they've let out units, their barns, we would also deal with any landlord and tenant aspects that necessarily come from that too.
Quite a lot of farmers also then sell the land off for residential development.
Selling for development, other diversification measures such as solar farms, battery storage facilities. And
that would be typically leased or sold to...
Usually long lease arrangements. There have been disposals.
And then one of the things which I haven't mentioned to you before we... so don't look too fearful. The farmers are also coming into this biodiversity net gain thing, so which I understand is... we touched upon it a little bit last week with Amy Summerton from Walton Homes, whereby the builder's building some land, and then what a farmer has some sort of newt storage pond on their farm to to sort of set off the one against the other. Have I described that extremely badly?
No, I don't think so. And the farmers will be paid to take their land out of agricultural use and use it as biodiversity net gain. It's not just farmers. This may be other landowners too who've got land that they wish to enter into one of these schemes, and they do that via the local authority to make their land available for one of these biodiversity net gain schemes.
And, as interestingly, the sort of cutting edge of some of this, you've done some of the first ones of these, been involved in them. So if anyone both has got land that they're interested in diversifying in that regard, you can help them.
Yeah, certainly.
I get it that there isn't sort of a specific farming law isn't in and of itself isn't a sort of type of law. In some respects, it's a better description for the law that farmers and agricultural people and the agricultural industry need to engage in. But there is agricultural legislation, of course, around food production and all that sort of stuff. But in terms of the work that you do, I'm gonna mispronounce this, but I always remember there being sort of two types of farm tenancy. Go on, enlighten me on.
So those farmers who don't own their own land, so typically own the freehold of their own land, may have lease arrangements. Of course, lease is very valuable. Mm-hmm. It's a proprietary asset, just as you have the freehold. And legislation has particularly two types of tenancy typically that you would find. So the older type tenancy, so pre-1995, Agricultural Holdings Act tenancy, or colloquially 1986 Act tenancy, you may hear that referred to. And then the more modern types that you see now, which are post-95, which are called farm business tenancies, which you
mostly find now. Is that the default if you enter into that sort of lease now? It's post-1995?
For agriculture.
But there's still loads of the 86 ones about?
Yeah. You still see the 86 Act tenancies, particularly amongst families that farm the same piece of land under that tenancy arrangement for generations.
What's the difference between the two, really?
So the 86 Act is very, very tenant friendly. It gives a tenant a lot of rights. It can
virtually impossible to kick them off.
Yeah, in certain circumstances, it can carry succession rights.
You can pass it on to your descendants.
Yeah. So it gives a great degree of security of tenure. A farm business tenancy is a post-1995. It gives more scope to the landlord and tenant to agree what the terms are, and they can be more flexible to allow landlords to get possession back or tenants to give up the tenancy. And crucially, they don't ordinarily carry any succession rights.
Yeah, you can't pass that on. So, go on. What was the one before that? Is it like a 48 Act or something like that?
Yeah, I mean the 86 Act tenancy did have pre-runners, but they were mostly similar.
I'm terrible on this podcast, right, for not having mentioned that in the preparation, and then go so what? Yeah, what about the 1954 Act? But I know that's the Landlord and Tenants Act generally. I'm just trying to impress you with my broad.
I mean, all these acts that I've been talking about are sort of policy decisions are about giving tenants security of tenure.
Yeah.
So
which is the sort of post-World War II.
Yeah, to stop, to give them security to be able to stay on the land or in their business property, if we're talking about the 1954 Act, without fear of their landlord being able at a whim to ask them to leave.
Sort of readdressing ownership generally sort of post-World War II, right?
Yeah, where there's a lot of leasehold property and still continues to be.
That's quite a common way of farming, right?
Yeah.
And in terms of, you mentioned compulsory purchase and HS2, I believe sort of over, I know that our predecessors spoke a lot about, I'm still dealing occasionally with bits of it now, but the compulsory purchases around the construction of the M6 toll road when that was built, and the HS2 has kept you. Most of it surely is bought now, but it kept you very busy, right?
So, yeah, I mean, from our practice over the years, we've dealt with the M6 toll road. There was then the upgrading of the the West Coast Main Line to 4 tracking, and then more or less straight away after that there came HS2.
Right.
Some unfortunately were impacted by all 3. We are still heavily involved in dealing with HS2 matters, although most of the land has either been compulsorily vested in the Secretary of State or acquired by the Secretary of State. There are still all of the compensation claims outstanding, and they are actively being pursued.
And we can help people with those.
So the landowner typically has got an agent involved who is negotiating the compensation on their behalf. As landowners, they're entitled to advance payments as that compensation claim progresses, and we assist with those and any other atypical sales that may come of that. I mean, I'm talking really about land here. I mean, we have also dealt with a lot of residential houses along the route that have been sold to the Secretary of State to make way for the scheme.
But it's not just where the tracks come through your land, is it? There's the concept of blight. If you're pretty close to it, the fact that that's going to have a
well, they had a
big
lot
impact.
of schemes running, and the blight being the main statutory that's the statutory scheme whereby if you were close to the line, you could effectively force the Secretary of State to buy your land. So compulsory purchase in reverse. So where the landowner is saying, look, I can't sell my property here now because of the existence of this scheme. Please buy it.
Yeah.
And then there were other schemes, sort of need to sell, which people were further away but found that they couldn't sell because they were impacted by the scheme and nobody wanted to buy so close, and they were able to ask the Secretary of State to buy the property from them as well. And then there were other compensation schemes depending on how far away you were from the actual scheme, whereby you could claim a sum of money.
And ultimately, actually, when it becomes a sort of double header between me and you, we've had a few of them whereby if it can't get sorted out, it goes to the, I'll get this
Lands
wrong,
Tribunal.
but it's the upper, for Tier 3 Lands Tribunal, which is sort of, it needs a better name, really, I would say. You know, it needs a more...
Well, I think all landowners have got to be aware that where they've had land taken from them and the land is vested in the Secretary of State, then there is a time limit by which they have meant to have sorted out their compensation claim.
Right.
And that ordinarily is 6 years from the date the Secretary of State took the land. If you are reaching that deadline, then
you need to get in touch
consider
quick. Yeah.
get in touch quick and either make a protective claim to the Lands Tribunal, which
Third tier, whatever. I've got a better name for it, by the way.
third tier.
No, I don't. Well, I don't know what it's tier something. Do you know? I've came up with a name for it then. Land Registry. It's not Land Registry Tribunal, is it?
No.
Land Tribunal. Final boss. Land Tribunal. Final boss.
So we
You did not think
we
that
have
was funny.
expertise in
Never
in the reference to the Lands Tribunal.
Well, we do, and I mean, I've been involved in a few of them myself.
Yeah.
We work closely, don't we, with some barristers and specialist land agents who are sort of mainly chartered surveyors, aren't they? And we've been helping our clients for, I mean, it's literally going back. Some of it going back to when you were a trainee.
Yeah.
I remember taking you down to a golf course that got compulsory purchased, and you got involved in that. Who were a client of mine on the employment side, and we were involved in everything that happened there, which has been quite interesting, and it continues to be.
So those time limits are rolling around quickly for a lot of landowners, particularly on phase 1. So they need to be mindful of that.
Well, I think people listening to this podcast will click this up, and hopefully it'll go. A few people will see this and will heed that warning and get in touch with us so we can help them out. Finally, I guess, and we've made it clear that we're not accountants, we're not specialist tax advisors, we're lawyers, but one of the biggest changes that's had an impact on farmers, and I know that politically they are protesting about this, is the changes to inheritance tax. And broadly, why is that a challenge for farmers?
Well, for 40 years, the correct tax advice really for farmers has been for the oldest generation to hold all of the property assets and die with their boots on.
They're Wellington boots.
They're Wellington boots, so that they can claim appropriate agricultural property, business property leave at 100%.
Yeah. Die owning the land and no tax to pay.
And you then pass on those assets to the next generation free of inheritance tax. The changes proposed will severely limit that, potentially to £1 million worth of assets to be passed over with no inheritance tax to pay, and then any balance payable at effective rate of 20%.
And I think that probably when this was being sort of rolled out in the press, and justification for this is a load of sort of rich, typically London-based business people who'd got a lot of money, and they'd buy up farms in effect to have an asset that was able to pass on to their children inheritance tax-free. But some of the sums and the inheritance tax and how families have set themselves up, these figures could be, the amount of tax that could be paid could be devastating to these farming families who've been farming these lands for generations. I mean, it's devastating if you farmed it for generations or not, but it completely changes the picture, right?
Well, it does. I mean, it's an overhead that the farms often can ill afford.
Yeah.
I mean, the rationale, of course, behind this is that a lot of people have bought agricultural land purely for the purposes of these tax exemptions, and those aren't necessarily your typical working family farmer.
I mean, the one counterpoint that I've put to this, I mean, you've experienced this, is that law that encourages, changing the law so it encourages the people who are actively managing the land to be the owners in that generational structure. In other words, for father and mother to pass the land on to 8-year-old farmer to pass the land on to his 6-year-old son. And I get that it's changed, and I get that these farms businesses have all been set up like that. But there is a logic in that to me. It is, to be having to sign the checks, to be having to sign the legal paperwork, that time of life, is a challenge, and there isn't a part of me that thinks there is a positive policy outcome to land being held lower down measures that encourage the 6-year-old to own it and not the 8-year-old.
I think most people accept that reform is required, but the speed at which this has been introduced has caught everybody off guard, and has actually caused people to have to take rather drastic decisions potentially very quickly. And
on one level, a lot of the time, people will not have sympathy for farmers, I guess, because they will be sitting on land that can sometimes, at least on paper, be worth many millions of pounds. Both me and you are sort of towny, town dwellers. I'm from Rugeley, you're from Burntwood, or you're going to now say you're from Hammerwich and that sort of rural. But having worked with farmers for so many, all of those illusions, it's a blooming hard job, isn't it?
It is an illusion as well, because that's a balance sheet exercise.
Yeah.
The value is locked in the land. The actual ordinarily, it's a very hard living to make as a farmer.
It is tough, and it's not like there's loads of money swelling around. I mean, there's a farmer I know very well, the Smith family out in Hampstall, Ridware. His main device for fixing things is a big metal stick that he carries in his tractor. And for the most part, if something goes wrong, he gives whatever the implement is a whack with that stick. And he can't get like a specialist electronical engineer to fix this, or a mechanical engineer to fix that. He has to fix it himself. These guys are slogging their guts out on our behalf, and I think people need to be a little bit more sympathetic to their plight. Well, Neil, thank you for joining me today. Hopefully people have gained an insight into what an agricultural solicitor does, if that's what we're calling you. I think we can call you that, can't we? Commercial property lawyer who specialises in agriculture may be a better way of describing it. Well, thank you